We have Sarah Galeski, Chuyen Hong Yule, Phuong Thi Minh Tran, and Thi To Nguyen from Tilleke and Gibbins, who will be discussing this particular topic. I'd like to introduce Chuyen as she's the panelist. She is the moderator for this session. Chuyen Hong Yule is a senior associate at Tilleke and Gibbins in Vietnam. She assists clients in areas ranging from employment to M&A. She has particular expertise in the healthcare sector, where she has advised many top multinationals on doing business in Vietnam. Chuyen also handles anti corruption matters and is regularly engaged to conduct compliance training sessions for clients. So, Chuyen, thank you very much. And the stage is all yours. Please feel free to start your presentation and introduce your panelists. Thank you.
Yes, thanks, Rahul. Thank you. Hello, everyone. Welcome to the second session of our in-house council event today. As mentioned by Rahul, my name is Yuy, and I'm a senior associate with the Tilleke and Gibbins based in the Ho Chi Minh City office. We are a full-service corporate law firm with offices in Hanoi, Ho Chi Minh City, Laos, Myanmar, Cambodia, Indonesia, and Thailand. You might be a little bit tired after a long working day. So we decided to structure this session as a panel discussion. And joining me on the panel are Ms. Sarah Galeski, Ms. Nguyễn Thị Tố Nữ, and Ms. Trần Thị Minh Phương. We are all working in the corporate and commercial department of the Tilleke and Gibbins. Let's hear our panelists briefly introduce themselves.
Hello, my name is Sarah Galeski. I'm a Canadian-trained lawyer and a foreign registered lawyer in Vietnam. I've been practicing law in Vietnam since 2013. I specialize in labor and employment law and compliance issues.
Hi everyone, my name is Phuong. I'm a lawyer at Tilleke and Gibbins and been with the firm for 5 years, including 2 years working as the legal secretary in a healthcare company. And I'm very glad to be here to join the meeting today.
Hi everyone, my name is Tố Nữ and I have been with Tilleke and Gibbins for about 10 years, and before I also worked in Chinese bank at the in-house counsel, and my practice specializations are TMT, tech, media, and telecom, and I also have many experience relating to contract laws and finance and banking. Thank you.
Yeah, thanks all the panelists for the introduction. In this session, we will mainly discuss how corporate and its in-house counsel can keep up with legal update and be coaches on common compliance issues and reduce the risk in the company's daily operations. So I believe that we have a good program ahead of us. Before we start, to the audience, just reminder that during the panel discussion, please feel free to drop your questions in the chat box, and we welcome your participation in the case study discussion. So let's get started with the first question. To the panelists, can you share with us or remind us on the new laws or draft laws that corporate, foreign investor, or its in-house should be aware of or should be worried about? Can we hear from Sarah? Yeah, can we hear from Sarah?
Sure. So there's a draft decree on personal data protection. This was released last year in 2021, and originally it was anticipated that the final version would be issued in December 2021. But basically, due to COVID, that has been delayed. This will have a big impact on basically many organizations. Any organization which wishes to process what is defined as sensitive personal data must obtain approval from a committee under the Ministry of Public Security. Sensitive personal data is defined pretty broadly. It involves like all health information, and information on personal relationships, information relating to someone's finances. So a lot of organizations will be caught by that. If you want to process this kind of information, you have to submit to get approval from this committee. you have to submit an impact assessment report setting out the possible harm to the data subjects and measures the organization is taking to minimize that harm. There's also very onerous obligations regarding processing this data. It's necessary to put in place certain equipment, software measures, and even to have regulations as to how the organization will handle complaints from data subjects about the processing of their information. And I'll just invite my colleague Nu to explain a bit further, since she's a specialist in this area.
Thank you, Sharon. Yes, and further to Sharon notes on the change under the draft decree on personal data protection. I just want to update to you about the status of the draft now. And actually, as you may know, that the government has approved the contents of the final version of the draft decree. However, the approved version of the document has not yet been published for the public to have to review. So actually, just a rumor that there is a lot of change under the approved draft decree, but we are still not sure that how many changes in comparison with the last version of the document that published for the public to provide the opinion. Moreover, it's assumed that the approval, the last stage for the approval of the document by the National Assembly still appears time-consuming. And as in our unofficial discussion with the relevant authorities, including the Ministry of Justice and Ministries of Public Security, it seems that they still have a lot of work to do, and it may take them about 4 months to even a half of a year to have the document to be issued. But I think that it's just in a positive case, but due to the practice of Vietnamese authority, the timeline may be still longer.
Yes, so thank you and Sarah for your sharing. And based on your sharing, so any problems relating to such draft law that you foresee?
I think it will be very onerous for businesses to keep up with this. Just from an employment perspective, if employers are gathering information about their employees, that involves things relating to their health status, for example. And this is pretty normal because often employers will ask employees to undergo a health exam before they employ them. So to process this kind of information or to do a background check, an individual's criminal record is also considered a type of sensitive information that would require this special approval to process. So employers are going to have to be prepared for a lot of administrative work. Preparing this impact assessment report will be fairly extensive, so that could be costly for a lot of businesses.
We got it, and we will be well prepared when it comes into law. And other than such draft law, can you also share with us some key new regulations from the labor employment aspect, Sarah?
So last year, decree number 152 went into effect, which regulates foreign employees in Vietnam. And it set in much stricter requirements for foreign employees. Some of the major differences were that years of work experience for an individual to be considered an expert or technician had to be from outside Vietnam. And this posed a big problem for foreign employees who are long-termers in Vietnam. So some individuals came to Vietnam in the 1990s and began in a pretty minor role and then worked their way up to CEO or something like that. And these people were facing a lot of difficulties under the new regulations. The other big change is that you are only allowed to renew the work permit once. And if you got your original work permit under the previous law and your work permit expires, then you have to apply for a fresh work permit under the new regulations with the stricter requirements. So this was also a problem for people. In recognizing an expert, the decree number 152 also eliminated the expert certificate which a lot of individuals would rely on if they didn't have the requisite university degree or something like that. So it is more difficult now. However, because of the COVID pandemic, the government issued Resolution 105, which relaxed some of these very strict measures. So under Resolution 105, a foreign employee can use their old work permit as proof of their work experience. So that is allowing people to use their work experience in Vietnam to qualify as an expert or technician. So that was a good development. So we'll have to see if some of the relaxations that were introduced with Resolution 105 actually are integrated into the regular law, or if it's just a temporary measure.
Thanks, Sarah. We just received the first question of our session today. So I just have a quick question for Tố Nữ. It's about the expected timeline that the draft decree come into law. We talked about the data privacy draft. Yep. This is a question from Ms. Thảo Huỳnh.
Yes, thank you, Chuyen, and thank you, Ms. Calvin, for the questions. Actually, the timeline I have just mentioned is the timeline, the expected timeline for the decree to be issued as the official law, regulations. However, I think that is impossible for us now to know on whether the decree will take effect immediately after the issues, or it will say some months later. However, it's just my personal view. I think that is a very important regulation, and it requires the relevant entity to have time to prepare for the compliance. So I think that I don't think that it will have effect immediately. Yes, it's just my personal view, and I want to share this with you. Yeah, thank you.
Yeah, thanks, Tố Nữ. And back to you, Sarah.
Okay. Some other recent developments. So last year, the new labor code came into effect, and it includes a lot of regulations about sexual harassment. So it requires employers to basically set out their investigation process and how they'll handle sexual harassment complaints within their internal labor regulations. Amending internal labor regulations is a very long process. Usually when you first submit the draft to the Labor Authority, they have a lot of amendments and it goes back and forth quite a few times. So it takes several months. So we would recommend to check the ILRs before this process of amending them to see if there are other issues. Phuong, can you explain some issues that employers should consider with their ILRs?
Yes, thanks, Sarah. I still have certain experience in working in the employment sector as well as working with the registration of internal labor rules. And from my experience, helping the internal labor rule to be amended and registered with the labor authority will take time. Normally, it will take around 1 or 2 rounds of review, and we have to revise and do the filing again. So from our view, it is recommended to divide the sections in the internal labor rule to just contain any necessary and statutory requirement under the labor law. While we should divide and separate to issue other policy in other matters. For example, leave policy, performance and bonus policy, and also compliance guide for the company, which I will further discuss in the next topic.
Yeah, so does it mean that once the company have the chance to review any specific provisions of the current internal labor rules or the work rules, they should review it as a whole document and in general, so that any amendment to the registered internal labor rules can be done or can be made at the same time at one time to save time for waiting.
Yes, okay.
Is that the correct interpretation?
Yes. Yeah.
Yes.
Yeah. And so I heard that the panelists have some case study to discuss and to share with the audience. So just wonder whether this is the correct time to move to the case study.
Sure. Just one last comment about the sexual harassment issue. One thing to consider, if an employer has not amended its internal labor regulations to update regarding sexual harassment, one of the problems they could face is they could have a situation where they cannot dismiss an employee for sexual harassment. So under the previous labor code, it wasn't really possible to dismiss an employee for committing sexual harassment because it wasn't listed as a dismissible offense under the labor code, and generally it was not possible to show that the harassment caused tangible financial damage, which is the requirement for any act of misconduct that is not listed under the labor code. So now it is listed under the labor code, but it would still be risky to try to dismiss an employee if it was not set out in your ILRs as a ground for dismissal. So that would be the big disadvantage. And also, I've written an article on this subject. So if anyone needs further information, please feel free to email me and I can share that article.
Thanks, Sarah. But when you talked about the sexual harassment new regulation, so is this like a big amount of work that the company should reflect in their current work rules, assuming that its current work rules doesn't have any regulation on this aspect?
Yeah. So they need to include a lot of details. They need to set out their procedure for handling complaints, remedies for victims. So it's quite a project. It's also important to train employees on the new regulations so they understand how they work.
I just feel one question from Eric from the chat box for the audience. So any noteworthy issues relating to setting up their grassroots trade union under the new labor code?
Yes, this is kind of complicated. So presently, Vietnam's trade union system is under the Vietnam General Confederation of Labor, and this is an arm of the Communist Party. So traditionally, this has been the trade union system. There's often a corporate level trade system, and then an immediate upper level trade system, which is the district trade union or the industrial zone trade union. So in the past, if a company did not have its own corporate level trade union, it would then have to deal with the district level one. However, Vietnam is changing its trade union system. This is largely because it's entered into the EVFTA and the CPTPP. And those agreements require Vietnam to ratify all the core ILO conventions. And one of these is freedom of association. So basically, Vietnam has to allow independent trade unions so people can choose which representative organization represents them. But with the independent trade unions, the decree setting out exactly how this will be managed has not yet been released. So we have to see how that develops. But what could be the situation in the future is there could be multiple trade unions within a company. So it might be more complicated to deal with in the future. Another big change is that under the new labor code, if an affected employee is not a member of the trade union, then the trade union is not necessarily involved, whereas they were in the past. So, for example, with a disciplinary hearing, a trade union representative always had to be involved, even if there's no corporate level trade union. It would be someone from the district level one. But now that wouldn't apply.
Yes. Okay, thanks, Sarah. We have another question relating to labor aspect. So it's from Ms. Ying Pham. Under the labor code, so must all companies issue regulations or rules on internal workplace democracy?
Yes, that's true.
Yeah.
So this came into effect a little bit before the new labor code through a decree. Companies had to have a democracy in the workplace regulation. So that was issued in a decree before the new labor code, but it's also reiterated within the new labor code. And there's also a recent decree setting out administrative fines, and companies can face an administrative fine from 10 to 20 million Vietnam dong if they fail to have democracy in the workplace regulation. So this is something companies need to do.
Yeah, so it's impressive that you can share like all the penalty in Vietnam dong, Sarah. Yeah, and to ensure that we can keep track with the time for the discussion, so can we move on to the case study? Yes, okay, let's do it.
For this part of our panel discussion, basically we'll give you a hypothetical situation, and we would like the audience to contribute their thoughts on each point. So please enter your comments through the chat, and we can have an open discussion on this. So our first situation is based on employment law, and an employee, Lynn, was discovered to have been stealing funds from the company. The first question is, what can the company do if it only discovered this issue 14 months after it occurred? So does anyone have any thoughts? Is there anything the company can do if they discovered it 14 months after it happened?
Yeah, so maybe Sarah, you can give the audience a hint to answer the first question.
Okay. Yeah, Vietnamese limitation periods are very tricky because they start to run from the occurrence of the event. Okay, maybe everyone is feeling shy. So a 12-month limitation period applies to acts of misconduct relating to the finances, assets, or disclosure of confidential information of the employer. But the catch is, it starts to run from the time of the occurrence of the event, not from the time it was reasonably discovered, which is a more common approach in common law jurisdictions. So you can be in a very bad position if your employee has been very good with sneakily concealing, stealing funds from the company. Basically, there can be nothing you can do. Okay. So moving on to the second question. If Lynn informs you that she is pregnant immediately after you issue the notice of the disciplinary hearing, what action may you take?
So this question relating to how employer deal with like female employees, right?
Mm-hmm. Yeah. So in this hypothetical situation, you found out. Okay, good. We have a response. Pause the hearing until she has delivered. You're on the right track. Anyone have any further input? Yes, Eric is correct. So there's a really long period of protection in Vietnam. So protected employees include those who are pregnant, on maternity leave, or raising a child under 1 year of age. Other employees who are protected are those on sick leave, those who are on some type of leave approved by the employer, those who are under investigation by the authorities. But with this type of situation, where the employee is raising a child under 12 months, another important point to keep in mind is this also applies to men. So I had one case where we were trying to dismiss a male employee, and we were kind of proceeding with the hearing, and then we found out that he had a baby at home that was 6 months old. That was a big problem. Okay, so for the questions, the second question is about if there's mutual separation agreement review and the employee informs you she's pregnant. You can still have a mutual termination agreement with a protected employee. So if you were in this situation, that would probably be the best approach. Otherwise, if she just got pregnant, you're looking at 21 months before you can start the disciplinary action. Then you would get an additional 60 days. And within those 60 days, you would have to do the disciplinary hearing and issue the disciplinary decision. So you don't really want to continue to employ someone for almost 2 years after you know they've committed a really serious act of misconduct. But you would be entitled to negotiate mutual separation. That is allowed.
So Sarah, when you share your opinions on this aspect, I just realized that in most of the work rules, the internal labor rules, there seems to have no requirements for the female employees to inform employers about her pregnancy status. And it seems like there is no way that the employer can be aware of this fact unless the employer is informed by the employee. So any advice how we can deal with this situation or reduce or minimize the risk?
I think you just proceed as normal until the employee notifies you. And then if it were a case like this, I think it would be appropriate for the employer to ask the employee to provide like a medical certificate saying that she's pregnant. But yeah, it can be tricky, like the other case I had where it was a male employee. So you didn't see any signs of pregnancy, but he did happen to have a baby under 12 months of age.
Yes.
So the final question, I'll just move on. Does the company have any legal obligations to report this crime to the police? What does the audience think?
Yeah, so while waiting for...
Okay, so someone says no. No, actually, this is incorrect. Under the penal code, if a party is aware of all the key facts surrounding a criminal offense, they technically have a duty to report the crime. The risks involved in this, basically, if you are aware of all the key facts of the crime, you're kind of between a rock and a hard place because you have this duty to report, but at the same time, the reporter would face liability or potential liability for slander, which is also a criminal offense. Or one of the instances of slander listed in the penal code is if you report someone of a serious crime which is fabricated. So if you're a company and in good faith, you believe you have evidence that someone has stolen money and you report to the police, but maybe the police thinks your evidence is not very strong and they find it's unsubstantiated, then there would be a risk of that person being found guilty of slander. These criminal offenses apply to individuals, not to companies. So it would be the employees involved in the investigation who could face liability and the employees tasked with reporting to the police. So it can be a tricky situation.
Thanks, Sarah. Thank you, Sarah. For any follow-up question on this labor and employment aspect, you can email any of us. Yeah, and especially Sarah. And so we can move to the next discussions about some other areas of laws, right? As we all know that one big issue that foreign investors have had to deal with in Vietnam is that there are many regulations that may impact their business decision and investment projects. So I want to ask Phuong if there are any new regulation on this particular aspect we should be aware of.
Yes, Thi Nguyen. In the last year, we have a new law on enterprise and law on investment, which take effect on the first day of 2021. Although frankly speaking, the change under two new laws are not too much significant in comparison with the preceding replacement in 2005 and 2014. However, if they still bring a lot of developments for the business operation and investment activities in Vietnam, proving that the government are trying to improve the environment for companies, domestic companies and foreign investors to the business in Vietnam. From the perspective of an in-house counsel, I think that there are few keynotes to take it into consideration under this new law. Among other changes, in a single member limited liability company, the company no longer needs to have an inspector, which is required under the old law. Secondly, the company now has only one code, for which is acting as the tax code and social insurance code, so that we can have one number for all three. Thirdly, the company stamp, which is always the important thing in every Vietnamese company. Company stamp is being relaxed in certain cases, and there is no requirement to notify or conduct any licensing procedure to effect the use of the new company stamp. Thirdly, the investment law and its guidance decree 31 provide a combined list of conditions of business activity for market access by foreign investors. We should combine this. We now can have a shop to check and review whether an intended in uh, activity fall under the condition of business line and which condition the foreign investor has to satisfy to do the business in Vietnam.
Yes, thanks for your sharing. And as I remember that there is there is also like a new regulations on the anti-corruption aspect. Yeah, can you please like remind us and the audience about this big change in the anti-corruption?
Yeah, relating to the anti-corruption aspect, we should move back 1 year. And in 2019, the mid of 2019, the new anti-corruption law has been taken effective. It actually a big change because it provides even very strict and more detailed on regulations relating to the anti-corruption in Vietnam. It extends the scope of application to even non-governmental sectors. And it also provides certain stringent provision to aiming to deal with corruption prevention and combat in the company in non-governmental sector. The new law encouraged every company to develop and build up an internal code of conduct or compliance guide, which is the implemented new and binding upon all employees and members of the company because you know that Vietnam is trying to improve the transparency and the environment for business. So the anti-corruption is one of the key and the major thing the government try to fix and to improve.
Yes, thanks for. So to summarize, it's about like the key change in the anti-corruption is aspect. So at this moment, the official cannot receive any types of gift from the corporate, right? Regardless of the amount of money,
Yeah.
the
Yes.
value of money.
Yes.
Yeah.
They raise lots of concerns on the Vietnamese company because we have traditional occasion to give gifts to the partners, to the customer, and even the government official on that holiday or on the big holiday in Vietnam.
Yes.
And yeah, and it's also the one of the case in our case study.
Yeah. So before we move to your case study, we received one question from the audience. It's about the what you have shared about the key change in the investment and like enterprises aspect. If a single member limited liability company already had an inspector, will he be dismissed due to the change of the law, or the company can just remain his position?
Because I assume that the charter of the company is still remain unchanged. So this position is still recognized and stipulated under the company charter. So unless the owner of the company decided to no longer no longer keep such position for the company by changing the charter, from my view, keeping him with such position is still fine.
Yes, thanks for. So it's time for your case study.
The case study more relating to the anti-corruption sector. We assume that we have company A is a Ho Chi Minh City-based medical device, and in its global compliance policy, the company is allowed to give gifts to the governmental official and healthcare professional not exceeding $50 and a meal to the same person not exceeding US. So based on such background, we have two circumstances. Circumstance one, the company plans to a budget to provide that gift to the doctor and key KOLs who have worked with it during the year. In the list of recipients, we have official at in a state agency and director in some public hospital in Ho Chi Minh City. The value of the total gift package is around 1 million Vietnamese đồng. So the question here is that under the new anti-corruption law and based on the additional background about the compliance policy, the company allowed to provide that gift as they plan. And we appreciate if the audience provide their answer as well as share any concern, opinion, idea on this matter, because I think it is quite common and happens sometimes in during the course of your daily activities.
Yes. So to summarize the question, so whether the company can provide consumable gifts, right?
Yeah.
To the doctors and the KOLs. Yeah, we're talking about like consumables because actually we received a lot of questions from our clients on whether it's just like a consumable gift and then without any corrupt intention. So whether it's still overcome the new regulation. So we welcome any thoughts from the audience. Share. So Phuong, can you just like give the audience like the answer for this question? Yeah. Just a confirmation because like maybe some of them have already knows the answer, but but they don't want just to type the answer in the chat box. So can you just give us a confirmation? Yeah.
Strictly speaking, from the base of law, the company is not allowed to provide any type of gift to the governmental official and in public sector. This is strictly prohibited under the anti-corruption law. For the doctor and other KOL will be outside the other than the government official. I think it is a matter of practice and custom in practice in common market, so it's still fine. Yeah,
Yes.
but Chuyen, can you please just share if your talk on this matter because you still have certain compliance training?
if I were one of the panelists, so I think that I can elaborate more on this aspect. But given the time constraint, and we still have like the one more case study to share to the audience, so I can just save it for another opportunities. And so I think based on the details you shared for the anti-corruption aspect, I suggest we can just skip like the second question and to move on like the next topic that Tố Nữ can share with the audience. Yeah, and just to ensure that we have sufficient time to deliver some useful piece of information to the audience today. Do you agree?
Yes. Okay.
Yeah.
Because I just saw a question on the chat box. Miss Officer Maria Chung to ask that did you say it is strictly prohibited, but it is still fine? Yeah, I think that it will divide two of person. The first one is the official government and the director of public hospital, which is considered as the SCP, and subject to the prohibition under the anti-corruption law. But for the remaining doctor, customer, or the KOL, I think it is a matter of practice, and we can do so.
Yes. So to summarize that, it will depend on the internal policy of the company, especially like the definitions of the officials and non-officials, right?
Yes.
Okay. But like for like the KOLs or any famous celebrities that can be like the speaker or the image of the company, right? And so you confirm that it's still possible.
Yeah, it's still
to do
possible.
so.
Yeah.
Yes. Okay. So we can move to Tố Nữ for her sharing. Yes. So Tố Nữ ơi.
Thank you,
Hello.
Chuyen. Yeah, thank you. Yeah, and everyone, I just have a very quick legal note for the banks that you should have more work in the near future, because under the new circular 80 of 2021, the banks and payment intermediaries will have the role that they need to cooperate with the authority to collect the tax from the cross-border online service providers such as Facebook, Google, Netflix, and so on. And I just know some day ago, on 21 of March, the government has launched the website, the portal for the the offshore provider to register the tax in Vietnam. So I think that it will be very soon that the tax authority will send the list of the offshore providers that have not been registered for the tax in Vietnam, and they will require the banks and also the payment intermediaries to support in collection of the tax. And that's on a very short note from me for the legal updates. And then I would like to move on to the case study. Yes, and it's a tip, a practical tip for the companies in dealing with the request from the authority regarding the employees or customer privacy. So it's very simple that if you receive a request from the authority to provide information of your customer or employee, how should you respond to such a request? The first one, you do not provide any information. The second one, you provide only the requested information. And the last one is that you can provide all information that may be relevant or helpful to the authority investment or action. If you have any thought, please share with us on the chat box. Yes, I see 2% to be, yeah. Yes, I think that is the right answer, but not the one that I want to have. Actually, I think that is also a possible option. Why? Because when you receive something from authority, I think that you will think that you need to respond, right? But yes, I can see that a comment from Miss Lee, right? You should know the purpose of request. Yes, I think that is one of the important things. I mean that we should challenge the request from the authority sometime. It means that as a legal counsel or an in-house counsel, you need to first determine whether such request is reasonable, legitimate under the laws. For example, if you work in banking sector, you can see that there is a decree 117 of the 2080 that guiding how to share the information of customer with the authority. And in that decree, they have the detailed guidance on what will make a request reasonable and appropriate for the bank to answer. So it means that if you receive a request, the first thing you need to do is that you need to research on the relevant law to see on whether such request is legitimate, and you under the obligation to answer the request first. And then if it turns out that the request is legitimate, okay, you will answer it. But then I think that B is a good answer too, because you only need to provide what the authority requests. You should not provide more than that, because for some, I know that some practice and before that, if the bank, for example, the tax authority asks a bank that for the information on the balance of an account, and then the officer of the bank in charge of this request, she found that the customer has more than an account in the bank, and she also provides certain information to the office, the authority. And I don't think that is a good practice, because the bank may face with the risk of receive some complaint or even some lawsuit from the customer, because in this case the privacy of the customer has not been respected by the bank. So unless you have any other questions, I think that is just one note for practical when handling the request from the authority.
Yes, thanks, Donu. Yeah, thanks.
Oh, yes, I see a question that what if there is a direct by an authority which the company may not have time to research if the request is legitimate under the relevant law. I think that yes, I understand your concern, but I think that in any case, the authority may give you some time as late, and you have the right to request for the time, reasonable time. Maybe not like for too long, but at least you should request, because it will protect your right, because you need to make sure that you are in the right position to answer the request. Yeah.
Yes.
And it will depends on the actual cases situation.
Yes. So thanks, Donu. And because it's related to like some of the compliance aspect I normally handle, so I want to add one more details to Veronica, is that sometimes even like we receive the request is too late, right? So from compliance aspect, it's advisable to conduct like some trainings for your staff so that they can be well prepared, just in case they receive like a certain order for an investigation or for a direct. Yes. So my advice is that like you can prepare a bullet point, do and don'ts for the staff to guide them how to handle the orders for investigation properly. And you can also like set down two circumstances when the request or the letter set out specific timeline for you to prepare the response, and also in case it is a sudden direct. Yes. So please be well prepared, and so that among other things, you can appoint one person, specific person from your company, to be the contact person, to be the one who speak on behalf of the company in case the company is visited by the authority.
And I also see the last question. Can we answer it, Chuyen?
Yes, we still have 3 minutes. Yes, so please go ahead.
So, yes, I saw a question that if we do not want to share the information due to our confidentiality policy, or the request is not reasonable, can we respond to the authority with a written explanation? Yes, actually, I think that in any case, you need to respond to authority in a written explanation. Yeah, but I don't think that due to your confidentiality policies can be a reason for you to refuse to answer the information the authority. Yeah, but if you can see that the request is not reasonable, you need to explain why you see that such request is not reasonable, and send the explanation letter to the authority. Yes, and Chuyen can ask, and also other panelists can ask about the confidential policy. I don't think that confidential policy of the company can help to act as a ground for refusing the request from authority, right? It's quite hard, because you know that the authority in Vietnam, especially when they have the right under the law, they may claim about your acts, and you may subject to some fines, and they may force you to do so. Yeah.
Yes, I would agree with you. Because assuming that like all the request is legitimate, so we need to respond. That's for sure. And in case we need to respond, just like ensure that we provide sufficient information in the response, and it should of course be reviewed by your legal department. Yes.
I just saw one question relating to an employment issue. The question says, what should the employer do when a creditor reports or claims to the employer that one of their employees has owed the creditor an amount and failed to pay debts when due? May the employer apply any disciplinary action after investigation, or is it just a matter of the creditor and the employer, or matter of the creditor and the employer is not required to take any action against such staff. So for this question, it sounds as though the employee has private debts that they owe to the creditor. So that would not be a workplace-related matter, and the employer should not be involved. Basically, the creditor can pursue its legal remedies against that individual, but it's not a workplace matter and would not involve the employer.
So thanks, Sarah, for taking the last question from the audience. And I think that we have a good discussion today, and hope that the audience feel the same. Yes, I hope you enjoy our panel discussion, and so we look forward to your participation in the next day of the in-house counsel event this year. Yeah, so thank you all for your participation. And if Rahul, you can adding some information on the closing remarks, so you still have 1 or 2 minutes. Yes.
Right. Thank you so much, Chuyen and Sarah and Phuong and Nu. I'm sorry. I think I have mispronounced all of your names previously. So apologies for that. But thank you very much for taking part in today's the day one of the Vietnam in-house community eCongress. Thank you very much again. You have a great day ahead, and see you all on the 31st of March at 3 p.m. On Thursday. Bye now.